Am I wrong to think that the liberal definition of hatred prescribes a significantly lower bar to convict of hate speech?
You're not wrong.
What do you believe should be available to students and families dealing with anti-Semitism when the person of authority, the teacher or the school, through a sanctioned activity, is responsible for it? That's what this report gets to, and I do hope you'll take a look at it after.
Do you believe that the laws in Canada, particularly those that pertain to the incitement of violence, are enforced equally and consistently across the country today?
Boy, that's a question that could occupy an hour.
Every Sunday in my riding in North York, a bunch of thugs show up in keffiyehs and they scream for intifada. The basic translation of the word intifada is violent resistance, and yet no arrests ensue. Let me ask you something. Do you believe that calling for intifada on a Canadian street is incitement to violence?
I believe it definitely can be.
Words. It takes words. It takes hateful literature, propaganda to start something.
This guy's garage. Like and subscribe.
We are beginning our second round today that'll go till 6:30. On this panel, we have appearing in their own capacity Mark Sandler as an individual chair of the Alliance of Canadians Combating Anti-Semitism. Hi, Mark. From the Canadian Teachers Federation, Cassandra Hallett, Director General. From the Network of Engaged Canadian Academics, Carrie Cogan, Professor, Deirdre Butler, Associate Professor. And from the Raoul Wallenberg Center for Human Rights, Brandon Silver, Director of Policy and Projects.
I trust that you're aware of the fact that you're invited here both by the Conservatives and by the Liberals.
It's good to hear. Thank you.
I think that speaks to your expertise on the issues to be discussed today. For 35 years, we used the Supreme Court's definition of the word hatred in Kigstra, an emotion of intense and extreme nature that's clearly associated with vilification and detestation. But the liberal definition of hatred is an emotion that involves detestation or vilification. They remove the words intense and extreme nature. And instead of being clearly associated with vilification and detestation, they just want an emotion that involves them. Am I wrong to think that the liberal definition of hatred prescribes a significantly lower bar to convict of hate speech?
You're not wrong in the sense that I wholly support the use of the precise language that the Supreme Court of Canada used in Kigstra to define hatred, because I am concerned that the definition that currently exists arguably does lower that standard, particularly in the use of detestation or vilification as opposed to detestation and vilification, and some of the other points that you've made. I do not want any excuse for a challenge to the existing hate propaganda sections of the criminal code based upon a perceived difference in the standard set for hatred.
And you've heard some of the other witnesses today articulating a concern that the proposed definition is unconstitutional.
Well, my point is that the Supreme Court of Canada upheld the hate propaganda section of the criminal code on the basis that it set a standard for willful, it set a standard for promotion, it set a standard for hatred. And that's what made the section constitutional. So I do not want to interfere in the slightest with the standards that the Supreme Court of Canada set, which was the basis for its determination that the legislation is constitutional.
Bill C-9 removes the requirement of the Attorney General's consent for the allaying of hate speech offenses. Are you concerned that politically motivated crowns or police may initiate prosecutions that aren't appropriate, and specifically, to go further, that vexatious litigants may litigate private prosecutions for hate speech and appeal decisions that try to end or block such prosecutions?
So I am concerned, and I have expressed that concern for over 30 years, that the Attorney General's consent is a safeguard against the frivolous and vexatious use of these sensitive sections of the criminal code. That's why I've proposed either the retention of the Attorney General's consent, notwithstanding the difficulties at times in getting that consent or getting that consent in a timely way, or as an acceptable alternative that the consent be retained for privately initiated investigations, because that's the real danger, the privately laid charges.
The new standalone criminal hatred offense can be laid in response to any offense contrary to any act of Parliament. I find that to be very concerning because we may attract criminal prosecution for what is otherwise civil or quasi criminal legislation. Would you recommend that we confine the application of the hate offense to conduct that is truly criminal in nature?
Well, I definitely agree that the hate offenses should apply not to quasi-criminal offenses, but to criminal offenses. So if there is concern about the scope of the present provision, then one can either deal with it by confining hate offenses to the criminal code, or what I would suggest is specifying the acts of Parliament to which it applies.
Bill C-9 repeals Section 430, 4.1, mischief, targeting places of worship because of bias or prejudice. Going forward, hatred will be required. Doesn't that mean that it will be more difficult, or a conviction for mischief against religious property would be more limited in scope if this section was repealed, if someone was to desecrate a church or a synagogue or a mosque?
Well, let me put it this way, because in essence I'm going to agree with you, but I'll frame it in my words. That's what lawyers do. What I would say is this, that I was an advocate when this section was created to show that the desecration of places of worship and other similar places be treated in a more serious way, and that's why this offense was created. And it need only require proof that the vandalization was based upon, was motivated by bias, prejudice, or hatred, which is a lower standard than hatred. I understand the use of hatred alone for direct offenses involving speech, but for the vandalism of religious institutions and the like, for me, this section should be retained as is. We shouldn't be making it more difficult to label the desecration of religious institutions as hate offenses.
I will take your invitation and I will phrase it in my own way, which is I believe that repealing this section will make it easier for someone to get away with desecration or mischief against a religious institution. Mr. Sandler, if a person intimidates someone as they're walking in, if they obstruct and intimidate someone as they're walking into their religious institution or their educational institution, isn't that already criminal under the criminal code? It could be mischief, it could be intimidation, it could be assault.
So as I said,
Mr.
so the answer is yes. What I've said is that the current proposed intimidation or obstruction sections don't make criminal conduct that is not already criminal. In my view, they send a signal to those who would be minded to commit these offenses. They assist law enforcement in giving priority to them, and they enhance sentences for it, but they do not criminalize conduct that is not already criminal.
Teachers across Canada are seeing more hate and intolerance in schools. So how can Bill C-9, in your opinion, reinforce the values that we see in the majority of our schools, which is safety, respect, and inclusion?
Very much. As I mentioned in my opening remarks, the Canadian Teachers Federation will really be in favor of any legislation that helps to ensure that schools can be sanctuaries where everyone, the students, of course, but also the education workers and teachers, feel safe. They're free from intimidation and harassment. And we're seeing, as has been said many times already in this room, an increasing rise in many forms of hate and violence across the country. So we do believe aspects of C-9, as well as potentially other legislation, which we'll speak about at other times, could really make a difference to ensure that schools are those sanctuaries. There's international declarations calling for schools to be sanctuary spaces. We don't see that being enacted in Canada. And we really do think that much greater clarity is needed in legislation so teachers can teach provincially and territorially approved curricula free from aggressive, hateful actions, protests, etc. And so that students who may identify from a vulnerable group can be safe going to school. That's one of our biggest concerns.
And so from your perspective, how does the law, Bill C-9, complement the work the teachers are already doing in order to build that inclusive spirit in their classrooms?
As mentioned, we appreciate the specific designation or reference to daycare centers in the legislation. There could certainly be more in the legislation related to schools, the K-12 system. Even though we recognize K-12 schooling are provincial and territorial jurisdiction, public safety is federal.
And can you provide examples of what work could be done?
We could certainly follow up with some specific language if that would be helpful.
Sure, you can submit something in writing to the committee and that would be looked at. Thank you. Over to you, Mr. Sadler. I just want to come back on the questions that were asked by my colleague, this idea of having a criminal offense and the civil component to it. And I'm very much interested in terms of, because we want to get this right, we just want to make sure that the law will have the effects that it's supposed to have. So in your opinion, I just wanted to have a clarification and a better understanding on the separation of the two and how you see it and how we can make sure that this piece of legislation would address exactly that hate and that it would be criminal in its nature.
Thank you for your question. I think what Mr. Baber was raising with me is the fact that the hate offense as currently defined applies to any criminal code offense as well as any offense under any federal statute. And so he raised a concern about whether or not any federal statute would incorporate quasi-criminal offenses that are created under other pieces of legislation, and as such undermine the purpose behind this, which is to address true crime. And I said that if there's concern about that, the way to address it is by saying that the hate offense section applies to the criminal code and specify the other offenses to which it applies, rather than leaving it open to all federal offenses that exist. Let's face it, this is going to be applicable, based upon my experience, in 99.9% cases to criminal code offenses.
Right.
So that's really where you want to strike at, labeling offenses as hate offenses that are conventional offenses under the criminal code, but also have the hate motivation.
Thank you. I have no further questions.
Mr. Silver, you had alluded to the importance of political leadership, and I actually agree that in the context of C9, we have to look at the broader context of hate and its origins. You would, I'm assuming, be aware in August there was an open letter signed by several Liberal members of Parliament condemning the rise of anti-Semitism. What do you make of the fact that only 31 Liberal MPs, a very slim minority, signed that letter?
The engagement by members of Parliament from across all party lines in combating hate is something that's appreciated by the centre I represent, and we take an all-party approach to our commentary on matters before the House.
Sorry, I'm not sure if you heard the question, sir. I asked, what do you think of the fact that only 32, I apologize, Liberal members of Parliament signed a letter denouncing the rise in anti-Semitism in August?
I would imagine that any member of the House, I would trust that any member of the House, given the opportunity to comment, would condemn anti-Semitism, and I, in my own experience engaging with members of the House, see that to be the case, that this is something that should be above partisan politics, the condemnation of anti-Semitism, and the strong support from all parties in the House on the matter.
Wonderful. So not signing a declaration condemning anti-Semitism is a bit of a problem. I'm glad we got there, Mr. Silver. Your organization's founder, Erwin Kotler, had actually advised Mr. Anthony Housefather, a Liberal member of Parliament, to leave the Liberal caucus over anti-Semitism at the Liberal Party. Do you agree with Mr. Kotler's advice?
I'm here representing the Raoul Wallenberg Center for Human Rights. You can feel free, you might want to consider addressing any questions about Professor Kotler's views on any particular electoral matter to him directly, I'd be pleased to comment on any aspects of Bill C-9.
But you did mention political leadership as being important. Do you think there has been leadership from the Liberal Party on anti-Semitism in the last 2 years?
So the references to political leadership were with regard to what tangible...
Sorry, I appreciate that. Do you believe there has been leadership from the Liberal Party of Canada in condemning anti-Semitism in the last 2 years? Yes or no?
So what we call for here is...
That is a yes or no question, Mr. Silver. Are you declining to answer?
In condemning anti-Semitism...
Okay, I reclaim my time, sir, if you're not going to answer. I'd like to turn to you, Ms. Hallett. You mentioned protecting teachers against hate. So your concerns on Bill C-9, your engagement on C-9, regards to what you think is directed or what you're identifying as being directed at teachers, correct?
Partially correct.
Okay.
Our concern is for everyone in the public school system, teachers, students, education workers. We're deeply troubled by rise in hate against students from vulnerable groups, as well as educators from vulnerable groups.
Have you read the Government of Canada report, Anti-Semitism in Ontario's K-12 Schools?
I have not read that specific report.
So
However, I've read many reports on increasing violence in schools and been part of many resources to create safe, inclusive spaces for our schools.
One of the takeaways from the reports is that of the thousands of incidents, a great many of them are anti-Semitic incidents, 1 in 6 anti-Semitic incidents involve teachers or school-sanctioned activities. Does that concern you, that teachers and schools are actually involved in perpetuating hate against students?
Any perpetuation of hate is a concern. I would not comment more on a report I haven't read and one statistic that's been pulled out of context for me, but I can assure you that the vast majority of educators across this country are doing their level best to create safe, inclusive environments for all of the students in their care, and they deserve the same as educators.
What do you believe should be available to students and families dealing with anti-Semitism when the person of authority, the teacher or the school, through a sanctioned activity, is responsible for it? That's what this report gets to, and I do hope you'll take a look at it after.
And I will. I won't speak specifically on Ontario matters, as we are a pan-Canadian federation representing the teachers' unions and educators across the entire country. But I can again assure you, as an educator myself, that in every province and territory, there are mechanisms in the teaching profession, in public schools, just as you find in other professions. If someone is out of bounds, so to say, if their conduct is inappropriate, if they, as the example you're citing, are inciting hate, then there are mechanisms for follow-up, appropriate channels for addressing that, for complaint, for discipline. Please don't think that that's any different than another issue. There's absolutely recourse if someone is conducting themselves inappropriately. Thank you.
Thank you, Ms. Hallett.
Let me ask, Mr. Silver, do you agree that regardless of whether some of these measures in C-9 would essentially reformulate certain elements in the criminal code, that they send an important message to police and to prosecutors, and send an important message to provinces and municipalities that these are important to the federal government within our sphere of jurisdiction, that we want them to act? Because a lot of the complaints have been that they are not acting. For example, the intimidation and obstruction offenses. Do you feel that these intimidation and obstruction offenses will assist police in actually charging people who are blocking access to buildings?
Fellow witness Mark Sandler gave a very compelling and comprehensive response to some of those matters, which I would indeed echo. The signaling, from a deterrent standpoint to those in breach of the law, what it adds to their record, and also the signal it sends to law enforcement and to partners at every level of government that this is a matter that should be a priority, that there is a requirement for enhanced enforcement that has been a large part of the problem until now, and which is why my reference to political leadership also with some specific recommendations about the FPT, federal, provincial, territorial meetings by the relevant ministers and their counterparts at every levels of government have not been sufficiently utilized for hate speech matters, and whether for questions of enhancing enforcement and coordination, a specialized working group could be created after a meeting, and surrounding the questions of Attorney General consent. I mean, it's presented as a sort of zero-sum game between the current clogged system where there's not enough movement on approvals and removing it altogether. But perhaps the FPT can also be a forum for enhanced cooperation between levels of government on approvals of prosecutions by the AG. I think there's other alternatives that can be offered to ameliorate the situation in terms of providing the relevant consent at the federal level and in partnership with provinces, territories, and even municipally.
And you don't agree that the careful line that has to be drawn between the interplay of Section 2 and Section 1 of the Charter to limit freedom of expression in certain contexts, I think you expressed it very well, is violated by the terms right now or the clauses right now that are in the bill?
And I would add that, there are other relevant sections of the Charter as well. Section 15 on equality, Section 27 on multiculturalism. There are multiple Charter values that come into play, and quite consistent Supreme Court decisions throughout several decades that uphold that narrowly tailored restrictions regarding hate speech actually align with not only Section 1 being a valid restriction, but also uphold the other sections of the Charter that espouse core Canadian values. And to your earlier question on, obstruction, on hate symbolism, there is an additional component of very specific proscribed symbolism. That is new and it's important. And, I had emphasized in my remarks why these symbols incite hate, why they are anti-democratic. And that is an important addition to existing criminal restrictions.
Mr. Chair, do I have any time left?
35 seconds. Often, Brandon can answer.
My last question is to Mr. Sandler. Mr. Sandler, you had talked about, you agree, Mr. Sandler, that C-9 should proceed. You agree that it's important, and you agree that law enforcement will get a good lesson from C-9 to actually enforce provisions that previously we all agree they have not been enforcing, perhaps the new ones and old ones. Can I ask you about removing the words of hateful intent as well, in terms of the limitations on flying the terror symbols? What exactly would you propose be changed in terms of what would you remove exactly?
Mr. Sandler, very briefly, or you can submit a written.
Very briefly, if you see my written submissions, I've set out a series of proposals that would more clearly tie the symbols to terror activities and would be a freestanding offense that wouldn't require proof of all of the elements of willful promotion of hatred. So I've set that out in more detail in my written submissions, Mr. Housefather. Thank you so much.
Mr. Sandler, if the bill C-9 isn't amended significantly, if the provisions remain as far as the AG, removing the requirement for the AG consent and as well as the watered-down definition of hate, could you support this bill in its current form?
The simple answer is no. I want to see, I need to see movement on the Attorney General's consent, and I need to see movement on the definition of hatred.
Do you believe that, you made some other points, I can't remember which question you were responding to, but you were talking about, I believe it maybe was a preacher in Montreal that you believed had violated the law as they are written. Do you believe that the laws in Canada, particularly those that pertain to the incitement of violence, are enforced equally and consistently across the country today?
Boy, that's a question that could occupy an hour of time. The bottom line is that I work with law enforcement right across the country. I do not believe that the current measures are enforced in the same way in every jurisdiction. Sometimes the laws are underutilized in some jurisdictions. That's not the case in other jurisdictions. So, no, I don't see an even application of the law.
Why do you think that is? Or why is that?
Well, I've set out in a discussion paper that was presented at the National Forum on Anti-Semitism a series of issues that I think have to be addressed. The first is that police officers have to be acquainted with all of the legal measures that are available to them to combat hate, and sometimes police officers are unaware of those provisions that exist. The second is police officers have to understand what forms of hatred exist in the context of anti-Semitism, what contemporary anti-Semitism looks like. They've got to understand what it means in order to apply the law effectively. And third, they have to be supported by whether it's municipal police service boards or municipalities, if they're municipal police forces. In other words, they don't direct the day-to-day decisions made by police, but they have to demonstrate a zero tolerance for anti-Semitism and other forms of hatred. They have to create policies on policing that should be implemented by the police force, and I see some of that not taking place right across the land.
With the concerns that you raised earlier that you then connected to not being able to support the bill in its current form, if the bill does pass in its current form without those modifications, what do you think are the what are the largest or most likely potentials for abuse, or the most worrisome potential elements for abuse?
Well, the two that concern me the most, the first is that I don't want to see in this highly politicized environment that we live in, private prosecutions being laid, for example, against Zionists just for being Zionists. And that's what we're going to see, efforts to weaponize the sections of the criminal code. And that could take place regardless of whether this legislation passes or not, but that's why the Attorney General's consent or the proxy that I've suggested for it is of concern to me. And the second is that although the courts may interpret the definition of hatred as being synonymous with the Supreme Court of Canada's decision, I don't want the risk of relitigating the existing sections of the criminal code and potentially coming to a different result. So those are two of the things that I would identify.
And just one final question that I had for you. There's been a lot of talk about some concerns surrounding the erosion of free speech and free expression in the United Kingdom and some of the laws there. It's not an area that I'm an expert in. From your opinion, is it justifiable to have concerns about the erosion of free speech and free expression and going down the road of essentially jailing people for making social media posts that some find distasteful or hurtful or even hateful?
Well, the answer is that I've proposed a new section, which is willful promotion of terror activity, because I don't like the looseness in the language that exists in the United Kingdom over glorification of terrorism, which I think is prone to the concerns that you've expressed. So for me, that's why I look at the terrorism sections that currently exist under the criminal code, and they're a hodgepodge, very difficult to apply for law enforcement, and law enforcement express concerns about it. And that's why I've crafted a potential section that's very narrowly crafted, that draws upon existing jurisprudence and recognizes that we do not protect under freedom of speech guarantees under the Charter the willful promotion of terror, in other words, violent activity. So I am concerned that we not go the route that the United Kingdom has taken. I don't think this legislation is doing that, and I certainly don't think that my proposed new offense would do that either.
Thank you. Thank you both. MP Chang for 5 minutes.
Thank you, Chair. Mr. Silver, do you think it's fair to say that freedom of religion and freedom from hate depend on each other, that both are essential to a safe and inclusive Canada?
Yes, and that's recognized in the Charter itself and in the precedent of the Supreme Court on hate speech provisions that were, as my fellow witness, Mr. Sandler, referred to, have been litigated in the past. They need not be relitigated. Protecting vulnerable groups from group vilifying hate ensures their equal participation in society, and anything less is an erosion of democratic norms that allow the fulsome participation of every Canadian, regardless of their background, in public discourse and in living their lives freely.
Thank you. Your organization has long championed for the protection of human rights and fight against anti-Semitism around the world. How does Bill C-9 advance Canada's broader leadership in these areas?
Well, there was a reference as well in my remarks to Canada's international obligations. And while the focus has been largely domestic and quite understandably so in terms of existing precedent and policy, there's also a corpus of international law that this dovetails quite effectively with, mandating the upholding of equality protections and also validating prohibitions on group vilifying hate. So this also brings this legislation, and particularly the components that I referenced in my remarks, bring Canada's legislation as well in line with international standards. This is something that has, again, been decided domestically by the Supreme Court, and also there is a corpus of international law and a number of international cases that uphold the legality of these provisions.
Thank you. This bill focuses on protecting access to religious and cultural spaces from hate-motivated interference. Why is this kind of protection especially important in today's climate?
Well, as I referenced in the opening of my remarks, in the last 5 years alone, there's been an increase to 20,000 hate crimes. There's an exponential growth, and there needs to be a concerted effort to address it. Now, this legislation is certainly not a panacea. It won't provide all the answers, but I think the important signaling that it does, the deterrence effect that it may have on would-be criminals, and the prioritization it would encourage by law enforcement makes a meaningful impact in trying to tackle what is indeed a crisis, and not doing anything would be far worse.
Thank you very much. And my next question is to Mr. Hollett. From your perspective, how does this legislation like this complement the effort teachers are already making to create inclusive, welcoming learning environment in Canadian schools?
Thank you for the question. I believe I touched on this earlier insofar as the legislation, as we've reviewed, really only focuses on daycare centres in terms of a specific education focus. So whilst the Canadian Teachers Federation welcomes that aspect of the legislation, there's not a lot in it that's specific to the K-12 school system from our perspective. Does not mean it would be unhelpful, but we are really eager to see much more being done at all levels of government to ensure that schools are safe for, as I've said before, students and all of the education workers in the schools. So it's not counter to making schools safe necessarily, but it doesn't go very far in terms of K-12 schools.
Thank you. My last question would be, how can this legislation empower our communities to respond more effectively when hate incident occurs, not just through justice system, but through education and prevention?
A piece of legislation, again, if I speak on behalf of educators, will only go so far. But however, if we can make strides in Canadian society to condemn hate in all its forms, that will be something that has a trickle-down effect for our educators and for their students, because as a society, we will be improving in terms of ensuring that we know hate in all its forms, whether it is anti-Semitism, anti-2S LGBTQ rhetoric, etc., is not acceptable. So certainly legislation that promotes safety and freedom could be helpful, but the specifics of how C-9 would help in K-12 schools, I think it would take some time, respectfully, to see how that would bear out.
Thank you.
Thank you.
Thank you. We'll have about another 10 minutes of questions, starting with Mr. Baber, then Mr. Chang, 4 minutes each, and then Monsieur Fortin to close things all off with 2 minutes.
Mr. Sandler, I appreciate my friend MP Gunn's exchange with you on the equal application of the rule of law. Every Sunday in my riding in North York, a bunch of thugs show up in keffiyehs and they scream for intifada. The basic translation of the word intifada is violent resistance, and yet no arrests ensue. Let me ask you something. Do you believe that calling for intifada on a Canadian street is incitement to violence?
I believe it definitely can be. The only reason I put a qualifier on it is because I always, as part of my training, instruct police to look at all of the circumstances and all of the words said in determining whether the requisite intent exists. But it is definitely capable of that, especially when coupled with other language that is clearly either genocidal or hate-filled.
If they have a character dressed and role-playing Yahya Sinwar, the mastermind of October 7th, would you call for the chance for intifada, incitement to violence?
Well, I've taken the position that some of the demonstrations that you're describing did cross the line into hate speech.
And yet no arrest from the Toronto police?
It's been very challenging to address situations where they do not involve kind of traditional forms of hate. So when you're doing the intersection of anti-Zionism and anti-Semitism, there has to be a better understanding of what's being said and when it crosses the threshold into hate. So when people are chanting, all Zionists are evil, genocidal, and racist, regardless, without distinction, that crosses into hate speech. That's very different than criticizing Israel, its conduct, its policies, its government, and the like. And those distinctions have to be better understood.
Mr. Sandler, it's okay for us to politely disagree. All I ask is for equal application of the rule of law, something that regretfully we're not seeing in this context, and we're hearing deafening silence from my friends the Liberals across the aisle on this. And this bill does not do anything to address any of that, because all of that is already contrary to the criminal code. I heard you say in your opening remarks that you're disappointed that willful promotion of terrorism did not make it into this bill. I'd like to take an opportunity to remind you that the former Conservative government passed promotion of terrorism into the criminal code as a criminal offense, and that in 2017, the Liberal government under Justin Trudeau diluted that law, in fact repealed some portions of that law, leading it to remain as only a counseling terrorism offense. Please talk to us a little bit about willful promotion of terrorism. What do you like to see added, and do you believe it will survive constitutional scrutiny if framed correctly?
Well, I have no doubt that it'll survive constitutional scrutiny because I've drafted the legislation for the consideration of this committee. It's contained in my written submissions, and I've drawn upon words that have already been constitutionally protected: willful promotion of, and then instead of hatred against an identifiable group, dealing with terror activities or the activities of a terror group, both of which terror activities and a terrorist group are defined already under the criminal code. So for me, there can be no constitutional protection for the willful promotion of terror activities or the activities of a prohibited group under the criminal code. So you can look to my written submissions for some of the language. For me, this would solve a number of the issues that currently exist.
Like what?
For example, when there's a fight about whether or not it's willful promotion against an identifiable group, namely Jews or Israelis, as opposed to whether it's political speech against Zionism, that shouldn't be the focus in all instances. The focus should be on whether you're promoting terror activities, and this would put the focus where it belongs for some of these cases.
Thank you.
Words. It takes words. It takes hateful literature, propaganda to start something. And you gave the examples of the Holocaust and the Rwandan genocide. This was very, very important to the work we're doing here today. Not 10, not 15 members of the Jewish community, but 6 million were subjected to the Holocaust. This all started with words, and thank you so much for pointing that out today here. And during the previous panel, I was actually having the same thoughts as you, that symbols are used to emphasize these things. It's the Nazi symbol, the Confederate flag. These were symbols used during the convoy right here in Ottawa. The Confederate flag, the Canadian flag being hung upside down, the Nazi sign painted on the Canadian flag. Conservative members of Parliament serving coffee and donuts to these people. Everything that happened was to intimidate and harass citizens. It was an attack on democracy. Can you please talk to us a little bit more about words and propaganda and hateful literature, as you were mentioning in your opening statement? Thank you.
Thank you, MP Dillon, and without opining on any particular, instance within Canada, the legislation itself is incredibly important in identifying specific symbols that are used in the willful promotion of hatred. It's a very narrowly tailored an elegant piece of legislation that tackles a growing problem. We see that the incitement that you so eloquently referenced in your remarks that underpin attacks against vulnerable minorities, these hate rallies that Député Fortin referenced, oftentimes they're accompanied by very specific symbols that have a specific context and with a specific and willful goal, and that is to intimidate vulnerable minorities and to ensure that some Canadians do not have equal access to their places of worship, to their schools, to their community centers, that they cannot live their lives fully and equally as Canadians. And these symbols are a part of that process, and this legislation makes an important point of pointing that out.
There are Holocaust deniers, and they use that as freedom of speech. Brian Mulroney said something very interesting in 2023. Firewalls were thrown up in the wake of the Holocaust, and this bonfire was reduced to flickering embers, but those firewalls, weakened by the passage of time and willful neglect, have been breached. Cloaked in the armor of free speech, fueled by hate, and stoked by the oxygen of the internet and social media, those fires now burn out of control. This applies in this context, but do you believe that this applies to other contexts where there are minorities, there are people from the LGBTQ community? Do you see these fires being stoked once again and see the slow erosion of civil liberties and all these rights of those who are vulnerable being violated? Thank you so much.
We won't have time for an answer, Mr. Silver.
If you can please give a written...
and that would be acceptable to us. So.